everyone. For our first issue, we are looking at whether Dr. Azlan breached the restraint of trade clause by opening a new clinic near Arif's clinic. The law we refer to is Section 28 of Contract Act 1950, which says any agreement that stops someone from doing a lawful profession or trade is void, unless it is reasonable. To support this, we refer to the case of Nagarevan and Millennium Medical Service 2011. In that case, Dr. Nagarevan opened another clinic within 15 kilometers after leaving a partnership. The court ruled that the clause restricting him was a restraint of trade and invalid, as it was too wide and didn't meet the standard of reasonableness. Now, in our situation, Dr. Azlan signed a clause that restricted him from opening or running any clinic within 3 kilometers for 5 years after the contract ended. This is quite extensive and may be seen as unreasonable because it could stop him from working in many nearby areas. However, what makes this case different is what Dr. Azlan did after. He opened BioCare Clinic just 10 kilometers away, used similar branding and color schemes, and even recruit former Arif staff. These actions show more than just competition. They show an attempt to unfairly take over Arif's business and reputation.
Issue number 2. This issue explores whether Dr. Azlan has breached his duty of confidentiality towards Arif Medical Sendirian Berhad. The central question is whether confidential information was used without authorization to the detriment of Arif Medical. So we begin with the legal framework. The test for breach of confidence originates from the English case Coco v. and Clark Engineers 1969. This test has 3 limbs. First, the information must be confidential in nature. The second one, it must have been imparted in circumstances giving rise to a duty of confidence. And the third and last, there must be an unauthorized use of that information among detriment. So this test was reinforced in Darnikas Malacca Sendirian Berhad v. Vision Kas Sendirian Berhad, where the Malaysian Federal Court emphasized that the plaintiff must clearly identify the confidential information misuse. Additionally, in iAdmin Singapore, the Singaporean court signaled a shift. If confidentiality and access are proven, the burden may be to the defendant to dispose of misuse. So in this case, several facts suggest potential misuse of confidential information. First, Dr. Azlan has access to patient data and internal systems under a consultancy agreement. Emails that indicate patients were redirected and unapproved suppliers were used. So, third, a new clinic was opened soon after termination with similar branding and digital infrastructure. If Arif Medical can clearly identify the specific confidential assets misuse, for instance, patient list or system data, then the COCO test may be satisfied. Under Darnikas, the pleading must be precise. If so, the burden may shift to Dr. Azlan to prove there is no misuse occurred as seen in iAdmin. To conclude, Dr. Azlan may be held liable for breach of confidentiality if Arif Medical can clearly demonstrate that first, the information was confidential. Second, it was shared under a duty of confidence. And third, it was misused to their detriment. The success of these claims depends heavily on evidence. Arif Medical should document exactly what was accessed and how it was reused in Dr. Azlan's new clinic.
I will discuss issue 3, failure to register as a regulated service. This issue questioned whether the agreement between Arif Medical and Past Diagnostics Sendirian Berhad is illegal due to the failure to register with the Ministry of Health. First, let's review the relevant laws. First, Section 10 of the Contract Act 1950 states that a contract must be made with a free consent of competent parties and its object must be lawful. Second, Section 24A specifies that the object of agreement is unlawful if it is forbidden by law. Third, Section 2G declares that any agreement deemed unlawful is void and cannot be enforced by law. Now, let's apply these laws to the case. In the case of Arumugam and Soma syndrome, the High Court rules that if the object of an agreement is unlawful, the entire agreement is void. Similarly, in this scenario, Arif Medical entered into an agreement with Pulse Diagnosed Syndrome Berhad for a digital health screening service. However, this service was not registered with the Ministry of Health as required under new regulation introduced in 2022. This failure to register renders the object of the agreement unlawful. In conclusion, under Section 24A of the Contract Act 1950, the use of Pulse Diagnostics Digital Health Screening Platform is prohibited because it was not registered as required by law. Thus, the agreement between Arif Medical and Pulse Diagnostics is illegal and void.
Next, I will be discussing the fourth issue, whether Arif Medical use of Pulse Diagnostics Syndrome Berhad Digital Health Screening Platform violates the condition of the public grant under the National Digital Health Program 2020. According to the Contract Act 1950, an agreement must be lawful and it becomes void if it goes against the public policy. Section 24E specifically states that the contract is unlawful if its purpose or payment harms the public welfare. In the case of Tong Fu Ching versus Shigenori Ono, a transaction was ruled void because it tried to bypass regulations which harm economic interests. Similarly, in this case, Pulse Diagnostics received funding under the National Digital Health Program 2020 with a condition that it could not be used for commercial profit for 5 years. Arif Medical started using Pulse platform in 2023. Even though the 5-year restriction had not ended, this means that Pulse had violated the grant conditions, making its agreement with Arif Medical legally void under Section 24E for opposing public policy on economic interests. In conclusion, since Pulse failed to comply with the grant condition, its contract with Arif Medical goes against the public policy and is unenforceable.
The sixth issue is regarding failure to comply with the agreement. In this case, Dr. Sarah withdrew from Arif Medical and began working with a competing virtual health platform and breached earlier agreement where she agreed that she would not work with similar program for at least a year after her involvement with Arif ended. So the issue arises whether Arif Medical can take a legal action toward Dr. Sarah Khalid for breaching an agreement. According to Section 10 Clause 2, stated that any contract is required to be made in writing or in the presence of witnesses or any law relating to the registration of document. To apply Section 10 Clause 2, there is no formal written contract was made between Dr. Sarah and Arif Medical. Dr. Sarah only has arrangement regarding her appointment as a teleconsultation for an urban women wellness project through email and did not receive any formal written contract. One of the law cases that can be related with the section above is the case between Polygram Record Syndrome Berhad and the search. The court held that the restraint of trade is void except fall within the 3 exceptions, as stated in Section 28 of the Contract Act. To relate the law with Dr. Sarah Khalid and Arif Medical Station, the agreement can be considered as a post-contractual restraint. Therefore, Arif Medical has no right to stop Dr. Sarah from joining another company. In addition, in the absence of the formal contract, it weakened the argument from the side of Arif Medical. In conclusion, Arif Medical cannot proceed with a legal proceeding against Dr. Sarah because it lack of a formal document and also written contract.
The sixth issue is whether Dr. Amir Iskandar's use of Arif Medical internal branding and materials in an external investor proposal amounts to a breach of contract under the Contract Act of 1950. Under Section 10 of the Contract Act 1950, a contract is valid if it's made with free consent, lawful purpose, and consideration. Section 26 generally voids restraints of trade except where they reasonably protect business interests like confidentiality. Section 40 allows a contract to be terminated if one party refuses to perform, and Section 73 permits recovery for unjust enrichment. Implied duties such as confidentiality and loyalty are recognized under Section 3 and 5 via common law. Applying this to the current case, Dr. Amir's use of Arif Medical's branding in a private investor pitch while still involved in its MPGS scheme suggests a breach of implied duties of loyalty and confidentiality. Although he hasn't formally launched a competing venture, his actions may amount to anticipatory breach under Section 40. Using proprietary content for personal gain could also lead to claims under Section 73 for unjust enrichment. These concerns may justify enforcing a restraint under Section 26 as it serves to protect legitimate business interests. To conclude, Arif Medical may have a valid claim that Dr. Amir breached implied contractual duties. Depending on the extent of his contract, the company could seek legal remedies such as injunctions or a claim for breach of confidence.
Second legal strategies or recommendation that can be taken by Arif Medical is formalize external or internal agreement, which is Arif Medical must ensure that all agreement with individual or third party are formalized in legally binding contract, including clearly stating company policies, obligation and post-contract restriction. In the case of Dr. Sarah, she breached the agreement by leaving Arif Medical and joining a competing virtual health platform, despite a non-compete clause requiring her to at least this 1 year restriction to join another similar company. However, Arif Medical could not pursue legal action because the agreement was not formalized in a legally binding contract. It was only offered through email, not through officially signed document. The third legal strategy that can be taken by Arif Medical to the legal proceeding is a misuse of patient and data and privacy. Arif Medical can take a legal action to Dr. Azlan as he allegedly has disclosed patient information by transforming a patient appointment reminder to his new clinic without consent. This constitutes a breach of a general principle according to Section 6 of the Personal Data Protection Act 2010.
As a conclusion, Arif Medical may take legal action against Dr. Azlan for breaching the partnership by diverting patients without approval, potentially falling under the exception to Section 28 of the Contract Act 1950. In contrast, action against Dr. Sarah is unlikely as no formal agreement exists, only an informal email offer, rendering it unenforceable. This highlights the need for Arif Medical to formalize all contractual agreements to minimize the future legal risk.